Now I have posted this. It is also.
Only a document should be finished before your lordship to elucidate the truth, whether my submission is correct with the facts or not. That's why on the very day.
Is it an appeal? Is it an appeal?
Partner,
What is this? An appeal?
this is the people are missed on 482 CRPs. And only the document is to produce.
Just see.
It was mentioned particularly.
I don't remember.
That vigilance case where the agreement is to produce.
I just see. I'll fix a date. We'll see and fix a date. Okay. Yes. I'll fix a date, but I'll look into the board and I'll. Two, 3 weeks over. Yes.
Pardon, my lord, a tighter bail is the second bail application of the petitioner.
Each application will go to the concerned bench.
The other clarification was
Concerned bench. Yes. That's all.
Item 1.
May I please allow? Last occasion, your lordship was inquired about the same, my lordship. Today the IO is present and they have filed the sub.
Can we have a copy?
So what is the grievance now?
They are saying, my lordship, this is mobile.
They've lost it.
Yes.
My lord, I think it matter of serious lapse, my lord. No, they cannot do like this, my lord. I'll indicate. No, I'll indicate one.
Say that there was no SIM at all.
How could he recover the details? My lord, I'll file an affidavit. My lord, a contempt should be initiated.
By using the hotspot.
My lord, yes.
Another mobile.
Yes.
They recovered.
How can they recover, my lord? How can they, if they don't have the SIM, how can they recover, my lord?
From the mobile.
It's unknown.
My lordship.
You are the IO.
My lord,
Exactly. Let us understand what exactly you want to try.
one time they said
Earlier the impression given was somehow the SIM was misplaced. That was the impression given to the court. Now the story which you are now saying in this reply seems to be camouflaging everything. What exactly has happened?
Mobile 2 times captain mother niche access करछन आज को order of the court court केतेबे सिम फिम कहीं के କିଛି नथु तापरे जेतले सॉफ्टवेयर कोड जरे गला सरे
मोबाइल जेतले आपण सीज कले ता भितरे सिम थिबो
सिम तले सिम
कोड पळेबो सिमटा सिमटा खसी पड़ेनी ना मोबाइल भितरे थाए.
so whether he was using the mobile phone on the envelope wherein the mobile phones were there, 2 SIM cards were folded in 2 small pieces of paper and were attached to
They might have misplaced somewhere.
Yes.
That's the fact.
My lord, I want to indicate how good they are. I want to indicate one thing. He's a responsible officer, my lord. When this matter started before the commission, my lord, they were supposed to be running a tape for the purposes of the photograph tape, that videography.
Yes.
My lord, what was the first videography? Let my learned friend say. Let my learned friend find out and tell the court. My lord, do you know what it was, my lord? We could have filed an FIR against the investigator IO. It was hardcore, my lord. 3x. Played for 2 minutes. when ladies were there, including my client, Miss X, which they call. And it was stopped. We ignored, all of us ignored it, including the commission. So what happens if we file an FIR on that, my lord? Who will be responsible for that?
How the
Just imagine, my lord, they don't clean it.
click came.
So lackadaisical. They're keeping the, without cleaning the pen drive. How can they do that, my lord? And that too, they are in a judicial commission. This is the way they
Yes,
investigate.
May I please,
Yes,
Your
sir. Because see, earlier it was said that the SIM was missing.
Yes.
Now it seems that they are trying to say that the SIM was not there at all.
May I please, Your Lordship, one thing can be done. Let the investigation is going on. I will ask for the copies of the seizure list. Let's see whether the mobile phone is with a SIM they have seized or without SIM.
See, what will be the fallback, suppose the SIM was not there according to them. Whatever data you have retrieved from the SIM, you can't rely as an evidence. It was not there, so where from you got?
My lord, there's something, something very unclean, my lord, in the system.
You file an affidavit.
Yes, ma'am.
And my lord, there is another petition we have filed, my lord, very interesting, my lord. My lord, they treat the lady, they treat everyone who goes to them, my lord, as if they're God themselves, my lord. So we are afraid the girl is even afraid to go to them, my lord, for the purpose where. My lord, I have filed an application. There was a scarf that was, with which her legs were tied, my lord. And they had pulled the hair, my lord. This much of hair was there with us, my lord. They said, either you come and give it to me, give it to us. It was there in the photograph also. Either they give it to us, my lord, when they go.
So what do you want?
No, my lord, we have that available, my lord. We'll place it before the court, my lord, will give it to them. My lord, we are afraid of going to that lady.
They pull your hair. How
Yes.
it has come to your hand?
Yes.
It should have gone to their hand.
No. Yes, I recovered it. I uprooted, and I was given a tissue for the purpose of cleaning myself. That is where that hair is, my lord.
That is not seized by them.
No, and the scarf is also not seized by them. And they saw the scarf in the commission.
You give it to them.
Yes.
See, annexure, IA number 57
In first item?
in CRLM number 1444 of 2024. The second one.
Yes. IA number?
IA 57 of 2025.
Today, my lordship, I received the copy. Let me check, my lordship. I will take the
It's number
instruction.
6, my lord.
6.
Annexure 1. That is the scarf that was used to tie her legs. That belongs to SI Sagarika.
It is in your position.
Yes.
Yes.
Because unfortunately, my lord, when they came, they gave it to me in the office. When they
Why don't you give it? It is part of the investigation.
Yes,
Do it.
we'll give it to my lord, and then my lord
Give
may
it.
give it to them. Yes. In the
Take it.
ये केस जे आज हमर अडिशनल मिलिया पड़ना बा
ये भी ଶୁଣନ୍ତୁ ଏଇ ଜିନିଷ ଗୁଡାକ ସେମାନେ ଦେବାକୁ ଚାହୁଁଛନ୍ତି for the purpose of investigation. What is the worth of it? You decide. Take it. Take it. You give it.
yes, my lord, they let them come in 1 hour time. I will give it to my lord. in a pen.
You go. I will not make a part of the record because it will look like as if I am guiding the investigation. I will not do that. ଆପଣ ଯାଆନ୍ତୁ କାହାକୁ ପଠାନ୍ତୁ ଏଇ ଦିଟା ଜିନିଷ ନେଇକି ଯିବେ ଆଜି ନେଇକି ଯିବେ ଠିକ
ଏଇଠୁ
ଅଛି
ନେଇଯିବେ।
ନେଇକି ତାକୁ ଆପଣ ଫରେନ୍ସିକ ରେ ପଠେଇବେ କି ନ ପଠେଇବେ ସେଟା ଆପଣଙ୍କର ଆଉଟଲୁକ୍
ହଁ, exactly.
କୋର୍ଟ କିଛି କହିବାର ନାହିଁ ତାହେଲେ ଠିକ ଅଛି ଆପଣ ଯାହା ବି କରିବେ କରନ୍ତୁ ଦେ ୱାଣ୍ଟ ଟୁ ଗିଭ୍ ସମଥିଙ୍ଗ ଟୁୱାର୍ଡସ୍ ଦି ଏଭିଡେନ୍ସ ୟୁ ଟେକ୍ ଇଟ୍ ଆଣ୍ଡ ଡୁ ହ୍ୱାଟ ଏଭର ୟୁ ୱାଣ୍ଟ ଟୁ ଡୁ ଦ୍ୟାଟ୍ସ ୟୁର ଆଉଟଲୁକ୍ and file an affidavit.
Notice they gave to us, my lord. This lady is afraid to go.
Shall I put it on 7th or 8th? You bring or see this SIM business is getting murkier now.
Yes.
You file an affidavit.
Yes.
Let them file affidavit. And the other day you said that it was missing. It was not there. Today another story. And day after you will tell another story.
Yes, my
So,
lordship. File in
Put it on affidavit.
Yes.
Put it on affidavit and you be careful what affidavit you are giving. And what will happen to the data you have retrieved from the SIM? If it was missing before retrieving the data or after the retrieving data, if it is before retrieving the data, you can't use that as an evidence at all. So therefore you give an affidavit.
Yes.
When, how and where you have lost it. You give.
And how did they ever get the material?
That's their
Yes,
outlook.
yes.
Let them file the affidavit.
Madam,
You
I
file
will-
the affidavit, I'm putting it on 8th. Huh?
Oh.
Put it on
15th.
15th. Let it be 15th.
15th.
Well, I have no problem because I mean, there's no
15th. But
good-
today,
what are they going to
today
do
within
about the
1
case?
hour, he has to collect all these things.
Yes, ma'am.
And you tell me. He has
Yes,
collected.
yes, my lord, my lord, I am making a statement and will record it.
I will not record it because it will be kind of guiding them to.
No, not guiding, I am giving
In the
it.
court instance, something cannot be seized.
No, the lady, no,
Yes,
no,
the
it-
affidavit you have
it's
given.
not seized, my lord.
Ah.
It's not seized from me. I am only saying that I will give it voluntarily to the.
You give it.
Yes.
She is there.
Yes, I'll give it to
I
her.
will not pass any order.
Yes,
to that.
that's all
I'll
right.
Simply put it on 15th, and in the meantime, the petitioner, the investigating officer, ଆପଣଙ୍କ ନାଁ କଣ? Narendra Kumar Bera, who is appearing in the court, shall file an affidavit regarding the missing SIM. इतना करके 15 तारीख रखो. And you take it
Yes.
and guide him to how to get it.
Yes.
Where from you get it? You just.
Madam, in fact, he forgot, my lord, it's coming. We will give it right away. In the few minutes.
ନେଇକି ପଳେଇବେ ଠିକ ଅଛି ନେଇକିରି ଯାଇକିରି and prepare whatever.
Yes.
I don't want to guide you. Anything will happen. I don't want to guide you. You are a senior officer. What to do, what not to do, you know that.
No, he's an outstanding officer, my lord. I have no doubt in his integrity or otherwise.
If they are giving some evidence to you, use that evidence whatever manner you want to use. Okay. Okay. 50. Yes.
Item 2.
Yes, madam.
CTA matter with regard to the mining. On the last occasion, my learned senior for the state had taken time with regard to
Yes.
examination of.
Have you got any information? Any instruction? Leave the matter after 2 weeks, awaiting the instruction from the state council. Yes. Next.
Item 3.
One week. On the request of Lieutenant Counsel of the petitioner, leave the matter after 3 weeks. Yes.
The 4.
May it please, your Honors. Item 4 is mine, na? Item 4 is mine, sir.
Ranjita Naik. Yes.
My lord, yesterday, my lord, in the last hour, I said something, my lord, regarding the payments of 20% of compensation amount of the share appeal number, where the appeal has to be admitted and before the additional.
You are the accused.
Yes, I am the
The
petitioner
accused,
lady.
I am for the complainant, your lordship. I am
Yeah.
for
My
the
lord,
complainant.
I am custody since, my lord.
Okay, okay.
This is not bail application, your lordship. Here, the accused already convicted, directed to pay for the rupees of 6
I
lakhs.
know 20% in 138 matter will you
Yes,
hand him
yes.
over?
Yes, my lord.
How much you will pay? I told you to pay something.
My lord, I got instruction.
Huh.
My lord, I only pay 30,000 at present. Thereafter, my
Illegal,
lord,
Mercy or what?
I will clear up.
Say you are not doing any,
It is-
press
is-
to the anyone.
No,
You are,
no.
you are a convict.
Yes, my lord.
20% of
My
order was passed.
my lord,
You have to pay, otherwise you will remain.
my lord, my lord, fact is that I was seriously ill then, and at present, my financial condition is.
10% within 15 days. And
Oh, within a
Immediately.
month, my, within a month, please.
No, my
Your
lord, my lord,
Within-
20% is the guideline of Honorable Supreme Court. Your lordship granting liberty for 10%. I am agreeing with that. For that also he is saying 1 month.
Mr. Sahu, try to be practical. You are interested in your money. Somehow you get the money. If you keep in the jail, you are not going to get anything.
Yes, your lordship.
And he must be having hard press in the financially. Otherwise, who would like to remain in jail in a 138 matter, you tell me? That's the ground reality. He doesn't have the money, therefore he is there in the jail. And somehow he'll arrange and give it.
My lord,
Huh?
10%.
10% within 50.
No,
20.
within 30 days, my lord. Within 30 days.
Then your
Okay.
lordship, 10% in 30 days, another 10% in another 30 days. Your lordship.
Okay.
That's fair enough.
Okay,
That's fair enough. Right, okay. Petitioner is agreed by the order dated 13/3/2025 passed by learned additional sessions at Kujango in criminal appeal number 26 of 2024, arising out of 1 CC case number 20 of 2023, whereby the appellate court has directed the petitioner to deposit 20% of the compensation amount awarded by the learned trial court while convicting the petitioner for offence under section 138 NIA. Petitioner, let the counsel for the petitioner submits that when you are taken into custody,
11/3/25, my lord.
submits that since the petitioner could not comply the order of the terms of the order impugn order, she was taken into custody on
11/3/25.
11/3/2020. Let the counsel for the petitioner submits that the petitioner is financially hard pressed, therefore is not able to raise the fund for complying the order of learned additional sessions at Kudango. He seeks the leniency so that he would comply the order and deposit the entire 20% of compensation amount. He further submits that 1 month time may be granted to him to deposit 10% of the compensation amount as awarded, and remaining 10% shall be deposited after 1 month, 1 month thereafter, one month there. Subject to petitioner giving an undertaking before the appellate court, that is before additional district and session judge Kujango, that he would be depositing 10% of the compensation amount within a period of 1 month or within a period of 4 weeks. The petitioner shall be released on bail. Petitioner shall be released on bail. The petitioner shall also give further undertaking that after expiry of after 4 weeks, after 8 weeks, the petitioner would make good the remaining 10% of the compensation. Ajiniyan, today you take the order and
Yes, yes, no.
and the additional session judge Kujango be directed to release the petitioner forthwith by accepting the undertaking, and after the deposit of 20% of compensation amount, the appeal of the petitioner be heard. With this observation, petition is disposed of.
My lord, I am small player for
Course of the
myself.
day.
Failing of the condition,
Huh?
failing of the direction of this honorable court, if he failed, my lord, the cancellation of bail.
I'll record that. It is made clear that no further extension in any circumstances shall be
Yes, yes.
granted to the
Yes,
petitioner.
yes.
Grateful, my lord.
My lord, in course of the day, order will.
Course of this. You
Grateful.
take it, later get out from the jail today, at least.
Obliged.
Grateful.
Will be sent. Okay, fine.
Might please your lordship. Petitioners have been selected for appointment in police, different branches of police. Now, when they went for receiving the appointment orders, they were said that there are cases against them. Some cases, one case is pending against them.
What
Your
are
lord-
the case?
Again, your lordship may kindly see page 12.
Writing and all.
No, against the Ognivir scheme, the aspirants for recruitment army.
I know that time that.
My lord.
Yes, what do you say?
I have given the entire order sheet, entire charge sheet.
And
No-
the entire India, this was happening everywhere. I issue notice.
Yeah.
Writing will, take counsel to file. Huh?
Item 5. My lord, let it be, unless it is disposed of early, they will not get the
I'll
appointment.
give it to immediately after 1 week.
My lord,
Immediately after.
My lord.
8th, 9th रखो, it will dispose of it. ठीक है?
in interim order that.
8th, 9th I'm keeping. Yes.
Belgium matter, lordship.
Give me the dates.
Earlier age in bail man 7/12/2016, lordship was 16.
Huh?
Page 16, 7/12/2016.
Ah.
Was well, subsequent page warrant has been issued, page 18, that is 24/1/2025.
500, yes.
This petition, Lord, has been filed, being to quash the affair, not knowing my limitations under the law, my lord, I will just place the affair. Just place the affair. If any case is made out against me, I have. Yes, my lord. Your lordship may kindly turn to page.
You're seeking quashing of cognizance order, what?
No, affair.
Entire.
FIR. Your lordship may kindly come to page 18. I'll not take to any other document, your
Yes.
lordship will see. The FIR, my lord, has been lodged by the complainant. Just see, second paragraph. Being a native of Orissa and having been born in Bhubaneswar, lordship got it?
Yes, I got it.
I was scouting for a plot of land at Bhubaneswar for constructing a house and relocating to Bhubaneswar to spend the remainder of my life with my near and dear ones. In the process, I made Sibo Sankar Mishra, petitioner before your lordship, so and so, who as per my information is a real estate broker, which I am not, Sri Mishra and his associate Bansidhar Panirai, residing in so and so, in respect of this khata number, this plate, plot number so and so corresponding to, stating that both have real estate rights in the Patia plot from us. Transaction price of the said plot was negotiated with so and so, the cross, against which an advance of rupees 65 was demanded. An agreement with the duo, the lordship marks this duo, was executed, namely Sri Mishra and Panigirai by me. The aforesaid advance was transferred by me from a bank account online to the savings bank account. This is important. The transaction of the land did not materialize due to dispute between the owner of the land and right to sell voters, mainly swords, notwithstanding the legal agent. This is one part of the affair. My humble submission is this part makes no complaint against, because that was fizzled out. Second is the allegation. Thereafter, your lordship has thereafter, Sri Panigirai requested additional time. Sri Panigirai, your lordship may mark. Thereafter, everything.
Another plot.
Additional time of 6 months to propose yet another plot of land. This was agreed as a last choice. While executing the cancellation MOU on plot number so with Bansidhar Panigirai to terminate and take entire refund. Though cancellation MOU, which was agreed, Sri Panigirai shall be legally bound to return rupees 10 lakhs in 5 installments and 20 lakhs or not before 6
Yes,
months.
yes, what do you say? This is
Your case of cheating. Because now.
I understand.
He will refund.
No, I agree, but not me. He is making an
Panigirai.
allegation against Panigirai.
but the 65 lakhs which you have taken,
No. That also, no. That transaction, the first transaction ended because no sellable right was there with the owner.
that money is now utilized for the second plot.
No, transaction of
It
the
looks
price-
like. Thereafter, Mr. Panigirai requested the additional time of 6 months
Yes,
to propose
Who?
yet another plot.
that is
But the money which was already paid,
Yes.
65 lakhs, for the earlier deal,
deal.
since it was not materialized, that money was also utilized.
That
for
is with
second
Panigirai.
plot.
That is with, but the MOU is
The money has gone to you.
that your lordship sees the cancellation date 21, page 21.
Yes.
That has been seized by the.
I'll issue notice. Let us see. This is a
Clearly said.
no. But the fact remains, this is a land dispute. The money is transacted. Either money has to be paid or land has to be given. As simple
He
as that.
says Panigirai will pay it. Panigirai has undertaken, executed the cancellation date,
Where is Panigirai?
the 21, page 21.
No. Have you implemented Panigirai? No.
No, he is the co-accused.
Go with you.
If your lordship wants, I can implead him, but kindly see.
Why can't you settle the dispute? You can't give the land. Why don't you pay the money?
Question is, it is entire, what is the, ଯାହାକୁ କୁହନ୍ତିନି ଶୁଆଟାକୁ ସେଠି ବଢିଲେ ଏଠି ମନୁଷ୍ୟ ବଢିବ. So, ସିଏ ତାକୁ ଧରି ପାରିବେନି. So, ମତେ ଧରିଲେ because I am a bedridden person, no way connected with this.
Okay, I'll issue notice.
Yes.
I issue notice to opposite party, written also. Mr. Manti, Land Counsel for the petitioner, has taken me to the FIR and the related document and submits that this is a pure and simple a case of sale and purchase of land from which advance money was taken paid. This being a civil dispute has all potential to be settled between the parties. Notice to opposite party, written note also. In the meantime, petitioner may move application before the trial court seeking additional. Yes.
stay,
Brief.
your lordship says
That I have said.
not because no coercive stays, because they will, the police will arrest me. The police will arrest me.
Then you have to go to the right court for bail. I can't help it. I'm
No, what-
by utilizing this order, you can
So
very well
what I'm
get
saying,
the
if your
bail.
lordship stays that, your lordship, then.
I've said that you move application owing to the fact that matter is.
No, your lordship has to keep it that way, that your lordship has
Yes.
said
Yes.
that also will.
I will, shall I
But
send
if
it
your
to
lordship
mediation?
wants, I'll make.
Shall
the
I
court-
send it to mediation straight away?
Unless that person. Yes, Lord, what I'm saying, anticipatory bail application was moved. It was rejected on a false assertion made by the complainant.
I'll help you in that way.
Ah.
Since this, the matter is arising out of a land deal where the petitioner appears to have land deal. Towards the same, the money has been transacted. It may be settled out of court. Therefore, I feel it appropriate to refer the matter to the High Court Mediation Center. Coordinator of the mediation center shall fix a date and issue notice to all stakeholders in the present case. And after exploring the possibility of a settlement, file a report before this court and use this for the reviving 438. Now you get to press.
And that previous order, let it be there. I'll move for adjournment.
Yes, that you do, but now 438
Yes,
is
yes.
changing circumstances.
Yes,
Refer to mediation.
Yes,
You get
obliged, very much obliged. Lord.
Therefore, I have given.
Very much obliged.
Item 8. And tell that Panirai to also participate because all stakeholders
All stakeholders, your lordship.
I have said. So
If your lordship wants, I can implead him also.
No, you tell him to come and settle with it, to pay the money and finish it up.
Because he has entered into an MOU settling it with the
So it's,
Panirai.
at the end of the day, it's money matter now.
Money matter.
Yes. Yes. 8. Huh?
I am challenging the annexure 8 series, my lord, page under page 61, my lord.
61.
Yes, my lord.
What are you saying?
Charge, my lord. Lord, what happened in this case, though it is not a case of Section 376, because the complainant is the
Were pleased to send it for mediation.
What?
They did second mediation, but they didn't cooperate. For which
Lordship,
You are appealing.
Lordship,
What is
I mean-
happening? Why are you doing like this?
Lordship, opposite party doesn't want to compromise this matter, Lordship. Or Lordship, it may kindly one adjournment. Lordship, we are ready to argue this matter.
My
Lordship.
lord, that
See,
is,
the matter was referred to mediation for the second time on the concession granted by the opposite party that she will be participating. She or he?
See, Lordship.
She will be participating in the mediation process. However, letter counsel for the petitioner, opposite party submits that the opposite party is not willing to settle the dispute. Regard being had to the same, leaves the matter for final disposal after 2 weeks.
my lord, may
The
I,
interim order passed earlier.
my lord, may I submit? The two students are there. They have been entitled to this case. And one OS officer, another is a government servant.
That's the reason they are not willing to do it. That's the precise reason. I
But the
understand.
student's life, my lord, because of that, may I
That is
pray
the
only?
reason I wanted that it should be settled.
That could be,
Unnecessary.
but your lordship, may I, only my prayer is your lordship may kindly fix a short date so that,
Short date.
yes.
Sure. See, I'll quash it to save the career of these people. You are so adamant. Court is giving indulgence to you
Lordship,
twice. At least you should participate. It fails, I can understand.
Lordship.
You may not be agreeing to some terms given by him or her. You, how audacity you have that despite the High Court's order twice, you made a concession that I'll participate. You don't participate at all.
Lordship, we are.
You don't regard the court's order, then why should any indulgence will be given to you? You can participate if something happens, you may not agree or may agree. That's a different story. Nobody can force you that you should settle. But at least you should regard the High Court order and participate in the proceeding. What is this behavior? I don't approve of this. Short look. I will take I will draw wrong inference about you. So sorry to tell you all this. Yes.
My lord, when the matter has been fixed, thus.
It's
Okay.
made clear that no further adjournment shall be granted in this.
Obliged.
I'll decide the matter this way or that.
Pardon, my lords. May I please your lordship?
33.
Both the parties. 34, my lords. Both correct, no correct.
Yes.
My lord, if I was lost under section 294, 341, 323, 324, 326, 307, 34 of the Indian Penal Code. My lord,
What are you asking?
My lord, I am asking for passing of the proceeding on the basis of compromise among the parties. Accused persons are present before my lords, including the informant, my lord. And the victim is husband of the informant.
Who is the informant?
Informant is the
They are the family member, madam.
all are family
Who
members.
is
ma'am.
So
Ranjani?
it is a daughter.
Upon Agu
Last order lordship directed to appeal before the court, my lord. Petitioner has come.
One chance may be given because today two meetings has been fixed for that reason he could not appear. The lordship may give you an amended next week. I have told him that matter may be compromise the matter, don't linger it. And he will appear on the next date positively, my lord. Today there is some urgent meetings fixed by the government for which he. There your lordship may indicate in the order that virtually can be.
Why? I'm allowing it. Anybody
Yes.
appears in virtually,
Yes.
no
Yes.
problem. No order is required. Then shall I, when you
My-
tell me the date?
My petitioner has come, my lord.
He's on so many things are.
Intimated, Ajib is a
Neither you
criminal
nor I
and-
can solve this problem.
In your lordship past experience, lordship.
Nothing will happen. And the
We
best
have
way
not
is best way is to transfer both of them to different places.
Yes.
No, they have already transferred.
What
Not
was it
now,
not
they are not in a one college.
Yes.
He has been transferred to
Transferred.
another college. And why he has transferred, he also circulated on aristocratic ground, he has been transferred. And a criminal case is pending against him.
Then keep on doing it. There are in every
We cannot stop those.
the government office, one, two people are like that.
We have no time to think about all of.
They spoil their life. They keep on running around courts and all instead of concentrating in their job.
Yes.
That's the what. Yes.
36.
Yes, may kindly see order dated 4/3/2025.
4-3.
2025.
Yes.
Because of the confessional statement of the co-accused, my lordship, my senior told that last occasion that he cannot, the serial MC may be caused. My lordship kindly have a gloss to the bail application. It was dismissed. My lordship. No, on that bail application, my lordship, and my lordship, he has also another case. It's with similar-
That is not the
similar
stage of
incident, my lordship.
initial stage. Initial stage, bail application rejected. That is true.
Not initial stage, my lordship. Now the bail application has been dismissed and he has got the bail on the ground of the medical, my lordship.
That which I have stated. I am absconder. I have surrendered.
And section 37 bar, because my lordship, he has similar antecedent, my
Your
lordship.
lordship may kindly see
Yes.
what is the intention of the legislation and what is the actually so much result of the consequence of the trial. Your lordship may kindly see what is left to be considered. That is to be looked into. Your lordship may kindly see my implication, that is finding of the trial court, that those accused, those two accused and wife and husband, those who are traveling in a vehicle, the vehicle belongs to them, they are the owner, they were going, they were later on arrested and confessed that the contraband articles they were carrying in their vehicle. And what confess? Now, on the instigation of one person, that is the petitioner. That is one part. Your lordship may kindly see.
In this case, this order.
Yes, my lordship. PS
But
case
that is
number
the
23
initial
of
stage.
2020.
That is initial stage. I don't dispute that.
No.
Stage, my lordship.
2022.
Time.
You have been granted interim bail.
Yes.
And
Then
you violated that.
yes.
Violated. That is why your lordship directed me to you first surrender, then I will consider.
You are in the.
Yes, I have surrendered.
Okay. You are.
I have
One
obliged.
minute.
Your lordship's order, I have complied.
You are.
I have complied your lordship order. I don't.
Where you are in custody since?
Well, 1 year, 2 months.
My lordship,
Already finished.
another one. of
Even if
my
accepting.
lordship. In same my lordship NDPS case, he was
He has antecedent, but in
अरे,
this
ये
case,
केस रे कौन अछि
whether you can secure a conviction in the chemical analysis
नहीं.
report
My lordship,
are proved.
my lordship,
किसी
let
भी
me
नहीं अधर.
face the trial.
I'll do one thing.
My lord.
I am giving 3 months to conclude the trial.
My lord, your lordship knows, even till today, the charge has not been framed. It cannot be, my lord. Your lordship may kindly consider, I have complied your lordship order. Because in view of, your lordship, during this period, he is a Muslim, and with all faith on me, he surrendered and obliged your lordship's order. Your lordship may kindly consider.
No,
what
he
he complained.
is not obliged, neither you
He is
Your
ready.
lordship may kindly say.
oblige the law.
Yes, and what would be the consequence of this case? Well, at least with single evidence is there, then I would have no case.
My
Then
lordship,
single
my
evidence,
lordship, another.
at least a single.
He was
Let him to say
bail.
at least a single evidence.
1 minute, 1 minute. What do you say?
In another case also, he was in bail on that, my lordship, because of the confessional statement. I'm showing that, my lordship. Because he is the offender. He used to give the drugs to the people, ganja to the people.
बिल्कुल
Then you
जहाँ कहउछंती मु कहउछि मु खाली गोटे प्रेयर करछि आपण जहाँ कहउछंती गोटे सिंगल एविडेंस के प्लेस कले गोटे
That's
सिंगल
the my lordship, because
जहाँ
of
भी
the
कहउछंती
confession.
आपण
Regarding.
गोटे किछि नहीं आगे आगे देखंतु
Not.
ए केस रे गंजेई नहीं गंजेई कुआडे गला केही जानना केमिकल एग्जामिनेशन रिपोर्ट नहीं इंडिपेंडेंट
What
मजिस्ट्रेट को डाके
what I'll do is balance would be 3 months time I'll give to trial court to conclude the trial and I allow you to move bail application and your bail application will be considered in view of the fact that the co-accused has been
acquitted and in view of the case of Tufan Singh versus
Tapanch. 3 months have
Your
given.
lordship
That will be
observe all.
balanced for both the things.
Yes, but your lordship now observe all, and I am on bail in all cases.
Yes, right on. I will not record that.
Yes,
I'll not record. Right on.
your lordship.
Petitioner.
Bit by bit, your lordship may mention so that I could able to get the.
Yes, petitioner is seeking
Let them to continue the trial, whatever they like.
Prosecution initiated against him, emanating from the Mudli PS case number 23 of 2020. 2020. How many accused persons were there?
Total three.
Out of 3 accused persons, 2 of them, namely Sudarshana Harijana and Bonita Harijana, were apprehended and they faced the trial. The learned sessions judge, special judge Malkargiri, in TR case number 88 of 2020, by its detailed judgment dated 26/11/2024, recorded in acquittal in favor of the said 2 accused persons. The petitioner is although the charge in the charge sheet the petitioner has been shown as an absconder, as a result of which the trial has been splitted up. After the recording of acquittal in favor of the 2 co-accused persons, petitioner has approached this court seeking quashing of the entire criminal prosecution against him on the ground that the prosecution miserably failed to establish the charges against the 2 accused who has faced the trial. Even to the extent that the chemical examination report also could not be proved.
And the executive magistrate has not been.
Could not be proved. The executive magistrate before whom the confessional statement.
No. The executive magistrate has not been called for at the time of seizure.
The seizure has become also doubtful because the executive magistrate before whom the seizure has taken place could not be examined by the prosecutor. Therefore, Mr. Maharaj, therefore,
Except the informant.
Maharaja, the counsel for the petitioner submits that in the no stretch of imagination, the prosecution could bring any iota of evidence to establish the case against the petitioner. Hence, subjecting the petitioner to the rigors of the trial is destined to be a futile exercise. He further submits that as per the direction of this court dated 4/3/2025, the petitioner has already surrendered before the court, and he has been remanded to custody. He has been remanded to custody. Mrs. Marana, on the other hand, submits that although the co-accused persons have been acquitted and the acquittal order has attained finality, but the evidence collected by the prosecution in the trial of the co-accused persons are vis-a-vis those accused persons. The benefit of the evidence as recorded by the prosecution for the co-accused persons cannot be shall not inure to the benefit of the petitioner. Confronted with such situation, Mr. Maharaja submits that insofar as even if the oral evidence recorded by the prosecution is may be taken into consideration. However, since the prosecution has failed to establish, failed to prove all the scientific evidences and other scientific evidence, the prosecution cannot improve the case insofar as the present petitioner is concerned, as the case of the present petitioner and the co-accused persons cannot be distinguishable. Evidentiary, the evidence of the evidence vis-a-vis the petitioner and the co-accused person cannot be distinguishable. Scientific evidence cannot be distinguishable. Taking into consideration the facts in entirety, fact scenario of the case in entirety, and by after perusing the judgment of the learned Sessions Judge in TR case number dated Sessions Judge dated 26/11/2024 in TR case number 88 of 2020. I am of the considered view that it would be expedient if the trial of the case of the present petitioner is expedited, and in the meanwhile, petitioner is granted liberty to move application for grant of bail by relying upon the judgment of Tufan Singh versus Swansea. Tufan Singh and
I have marked the paragraph.
Tufan Singh,
Tufan Singh and CORAM Talwar.
Tufan Singh and Karan Talwar. Karan Talwar by state of Tamil Nadu. Mr. Maharaja, by taking me to which paragraph?
I have marked.
Para 12.
Highlight.
Para 12.
Yes.
Para 12 of Karan Talwar, that is Supra, further submits that on the basis of the confession of the co-accused, the petitioner, the prosecution cannot secure conviction against the petitioner. Regarding to the aforementioned,
Trial court is directed to consider his bail application.
Although I am not inclined to entertain this petition at this stage, however, direct the trial court to do well to see that the trial of the case for the petitioner is concluded as expeditiously as possible, preferably within a period of 3 months hence. 3 months hence. In the meantime, it is open for the petitioner to move application for grant of bail. Grant of bail by relying upon the judgment of Tufan Singh Supra and Karan Singh Talwar Supra. With this observation, the petition is disposed of. Yes.
So,
Yes.
32.
The 2N, yes.
376 and 6 FOCSO Act is there, madam. That age of the victim is 19 years and that age of the accused 23 years, madam.
You say you settle.
Settle, matter settle, and my learned friend is appearing on behalf of the.
I am appearing for the
opposite parties.
What settlement?
That, your lordship, that one
What is the terms of settlement?
change of circumstance, madam, different casteism is there. So
No, what is the stage of the case?
a stage of the case, my lord, that unfortunately, previously I am not the conducting counsel. Thereafter,
Then get the whether she has already deposed before court.
that
Because
instruction.
see, have you seen my judgment? You
Yes, yes, my lord. That Rosalind
with
Rao,
exception, unless you know the facts, how will you bring it?
my lord.
I'll put it on 7th. 7th.
She has deposed.
Where is her deposition?
The previous council, we were not the previous.
So therefore, just collect it without knowing that if she has deposed, already deposed,
My lord.
you not get the benefit of that judgment. That's the answer.
It's present in the court.
Present will not make
Yes.
difference. The law will not change merely because she is present. You have to get over that hurdles.
But
We'll find out way
Yes, yes,
to
madam.
help it out. Not that we'll close it, but see the judgment. Just check it
they're
out.
not covered under their.
That's the whole difficulty because he has
That's-
already deposed. Then in one paragraph, I have said that once he deposes before the court, the 482 court can't scuttle it,
Yes.
My lord.
nullify the depositions. 164 she might have said.
Yes, my lord.
Again, she goes to the witness box and again she says. Then at that stage you come and say that I have settled. Then how will you get over those?
That instruction will be obtained, my lord.
You just
My lord.
if you can get some judgment, we can extend the
A
scope.
particular date may be fixed and that is a short date.
7th.
Next.
7th.
My lord, interim protection.
10th.
My lord, interim protection.
My lordship, but
Had I given interim protection?
no, but that allegation they have made, man, is a very serious. So I think they have to face the trial, my lordship. Let it be for my lordship.
What interim protection? He
Because-
is already facing the trial. Must be there in the
Yes, my lordship.
bail.
My lord, it,
10th.
there.
You come with all the.
Yes, sir.
Then we try to find out some way out. Huh?
My lord.
In POCSO, there is section 29. There is a presumption, man. Whatever the child says, that has been demolished at the time of trial only.
Let me say,
That's right.
what is the
So
case
in
of the
the
trial?
Supreme Court judgment, that has not been dealt with in view of compromise, but that has to be taken into consideration.
But see, all these things are all right.
Right.
Technically,
Right.
the offense is committed.
Yes.
But what is happening in the ground reality?
In adult
You
fitness,
don't
after
forget that you are in India. The different startup people, there is no education, nothing.
Right.
All these things are happening. What to do? You have to strike a balance. Technically, yes.
Yes,
But can you
In-
spoil the life of the
Yes.
young people like this?
yes, yes.
See what age of this boy?
It is 19 years and 23
Yes,
years.
yes,
my lord.
23 years.
Yes,
The girl is 19 years.
Yes, my lord. But there is no other, my lord, law book in statute, my lord, so like 29. 29 itself, my lord, shall presume.
That's right. I'm with you. But that is the reason 482 to meet ends of justice. You have to do some justice also. You can't spoil the life of the young people like this. You have to strike a balance.
Right.
So that is the reason. But if the evidence are such, you can't help it. That's the whole difficulty. Just check it up. What can be done?
So I am appealing for the opposite parties. That
Told to enter appearance in behalf of opposite party. Number 2 and undertake file the worker.